from Afford's criminal and family law throughout Massachusetts. Our fees are all based on a sliding scale based on your income. So the less you make, the less you pay. On today's episode, we're going to be talking about contested divorces in Massachusetts. What is a contested divorce? Well, we've already discussed what an uncontested divorce is. That's when all the issues are agreed upon between you and your spouse. As you may imagine, a contested divorce is one in which there's at least one issue that you don't agree on. Perhaps all of the issues, but there's at least one. So it can't go down the uncontested track. It must be on the contested track. Contested divorces are also referred to as 1B divorces. You'll hear that term as you go through the process. So I just wanted to let you know about that. So how does a contested divorce work? Well, what happens is either you or your spouse files a complaint, a petition with the court, the probate and family court, asking for a divorce. Among other things that are filed with the court, there are several documents that need to be filed. Chief among them are your financial disclosures. Both you and your spouse must file them. So whoever's filing the complaint files them with the complaint, and the person who is the defendant will be answering the complaint, so that you file an answer with your financial disclosures as well. And the financial disclosures are basically a very detailed rundown of your financial situation, all of your monthly or weekly debts, your income, your debts, and so forth. If you have any loans that need to be paid and that kind of thing. So that's what the financial disclosures are all about. So that needs to be filed. Then what happens is you need to file you need to file all the paperwork, and then you need to serve that paperwork, the complaint, and a summons upon the other party. So if you're filing for the divorce, you have to have your spouse served by a sheriff. So they just basically go out and hand them the papers, or perhaps leave it at their last known address or something along those lines. So you have to put the other person on notice that there's an open case involving them and when the next court date is scheduled. So because it's a 1B, you're going to have to go through the whole litigation process, basically. So you file your documents, you have them served, and probably someone is going to be asking for temporary orders. So whoever's filing the petition is the plaintiff. They will probably ask for temporary orders, things such as they would ask for temporary custody of the children, temporary child support, temporary spousal support, perhaps the exclusive use of the marital home, among other things. Those are the main things that a temporary order typically addresses. So the temporary order will go into place after a hearing, and that will be the sort of the rule of the law for the pendency or while the case is open. That can, of course, get changed at the end of the case. It can also get changed during the case if circumstances change and the judge finds it necessary to change the original order. So after that happens, you're going to go through the discovery phase. And discovery is just a phase where you're exchanging information between the two parties. There are a few ways of getting discovery. One of them are interrogatories, which are basically written questions that the other party must answer under oath, and you're asking all kinds of information about their finances and so forth. And there's also a request for documents. The documents to be provided are typically also financial documents and so forth, anything to do with a person's retirement account, because that's divisible as well. So it's those kinds of things. And if the case proceeds down the litigation route, we're probably talking about depositions that need to be taken. A deposition is kind of, think of it as sort of a mini trial without a judge that's present. So what happens is somebody schedules a deposition for, let's say, the other person. So their depositions are typically held in a lawyer's office, where the parties are present, the attorneys are present, and a stenographer is present. So everything is so there's only one witness, that whoever that witness is called to testify, that person is put under oath and subject to questioning by the other side. And of course, there's cross-examination and redirect examination. As I say, it's sort of like a mini trial. There are objections, but there are no judges there to rule on the objections. The reason why an attorney would object at a deposition is they're preserving their right to argue that point before a judge. If they don't make an objection at the time of the deposition, they've probably waived their chance to object to that question and the answer coming into evidence. So the discovery phase goes on for a period of time. At some point, the case, if both sides still can't agree on all of the issues, a trial will be scheduled. A trial is held before a judge, not a jury, but a judge of the probate and family court. And it's just like you see on TV. There's someone will call a witness. They will examine that witness on direct examination. The other side will have an opportunity for cross-examination. They could be redirect and re-cross-examination as well. So the parties typically will testify, and there could be any number of other witnesses, and any supporting collateral sources that you have. Sometimes people will come in to testify about the behavior of one party or the other, or forensic people if there are accountants or something evaluating, say, a business or some sort of asset. So a trial takes place, and ultimately a judge will make a decision on all of the issues that have not been decided. What happens is at that point, the judge will, once the judge makes all the rulings, a separation agreement will be drawn up by the parties in conjunction with the judge's decisions. And that separation agreement is the document that addresses all of the issues in the divorce. So who gets the home, who gets the kids, what is the amount of child support, is there any alimony? If so, how much and for how long? How are the debts divided? How are the assets divided? Everything is contained within that separation agreement. Once that happens, once the separation agreement is entered by the court, a period of what's called a divorce nisi goes into place. And a divorce nisi is basically a waiting period. In this case, it's 90 days from the entry of the separation agreement. So you don't have to do anything during that 90 days. It's just a waiting period. That's in case people change their mind. You may find it surprising, but some people do change their mind. Even after all this, they say, let's give it one last chance or whatever. Let's stick together and try to work it out. So that's the reason for the 90-day waiting period. You don't have to do anything. If you don't want to get back together, or there are no issues that crop up, newly discovered evidence of some sort of hidden asset or something along those lines, at the end of that 90 days, the divorce judgment is entered as a final judgment. So again, you don't have to do anything during that period. It just enters automatically as long as you don't and your spouse doesn't change their minds. So that's really a very short rundown of what a contested divorce is in Massachusetts. It's much more expensive and it takes a lot longer than an uncontested divorce, because those issues all have to be litigated. So if you can, it's always best to try to work things out with your spouse, but that's oftentimes not possible. So again, at Afford Law, we practice criminal and family law in Massachusetts, and we do so on a reduced rate. So our fees are based on a sliding scale based on your income. Again, so the less you make, the less you pay. We've been able to help hundreds of people throughout our years in practice in criminal and family law matters. We use very experienced attorneys, divorce attorneys and criminal attorneys who have your best interest at heart. So if you have any questions, please feel free to visit us at affordlaw.org, not com, but affordlaw.org. See if there's any information there that you can use, and feel free to book a virtual appointment. It's free, there's no obligation, and I'd be happy to answer any questions that you might have. At Afford Law, we're making justice affordable. Thank you.